And so we proceed to the 10-minute rule motion. Mr. Barry Shearman.
Thank you, Madam Deputy Speaker. I beg to move that leave be given to bring in a bill to amend the Criminal Appeal Act 1968 to allow leave to appeal an unspent conviction where there has been a material change in the law, notwithstanding the date of conviction and for connected purposes. I'll declare my interest as co-chair of the All-Party Parliamentary Group on Miscarriages and chair of the Future of Justice Commission. Before I begin, I would like to pay tribute to the wonderful volunteers in Jengba, the Joint Enterprise Not Guilty by Association group, for their tireless work, campaigning against miscarriages of justice for so many years. It's great that I believe somewhere in the House they're here today, and I thank them for joining me yesterday for our launch event. I would also like to thank my good friend and colleague Glyn Maddox, who has been unwavering in his determination to see these injustices put right. And this is a very great coalition of people campaigning for justice in this particular matter. Way back in 1992, when I was Shadow Home Secretary Roy Hattersley's deputy, it was a time of the Guildford 4, the Maguire 7, and I became very much involved in those controversial cases. And since then, fighting miscarriages of justice has been a core passion of mine. Through the All-Party Group, we started a commission which produced a leading report on the Criminal Cases Review Commission, the CCRC. That report's recommendations are being well received and used as far afield as Canada, and indeed the Law Commission are now reviewing the real possibility test in our country. For those who suffer a miscarriage of justice, it has a truly devastating consequence, not only for them, for their families, for their neighbours, for their community. It is vital that we as parliamentarians do everything that we can to ensure that quick and effective mechanisms are available to right the wrongs when they occur in our criminal justice system. And Madam Deputy Speaker, no criminal justice system is perfect. One cause of miscarriages of justice is the legal doctrine of joint enterprise. Joint enterprise is a wide legal doctrine, so I'll be focusing on one aspect of it, that is parasitic accessorial liability, or PAL for short. PAL is where two or more people commit a criminal offence, and during the commission of this crime, another individual goes on to commit a further, usually more serious offence. All those who committed the first crime will also be liable for the second crime if they foresaw the possibility that the offence would occur. It was formulated in 1985 by the Privy Council and brought into English law by the House of Lords in 1999, and it has received much criticism from practitioners and lawyers and academics for being both unclear and unfair. And one of the reasons for this is that the doctrine has resulted in the anomaly whereby it is easier to convict the accessory rather than the individual who physically committed the crime. The law has also disproportionately impacted marginalised people. For example, young black working class men have been severely overrepresented in convictions under joint enterprise, according to a study by Manchester Met University. Jengba, who I paid tribute to earlier, have said that around 80% of the people who contact them are from black or minority ethnic backgrounds, and mostly from working families. Additionally, it is often the individuals on the autism spectrum that are impacted by joint enterprise. I'm very much involved in the Westminster Autism Commission, and this area of joint enterprise particularly concerns me. The way in which the criminal justice system has dealt with autistic people in joint enterprise cases has been nothing short of a travesty. Names such as Alex Henry, Asima Brown will be familiar to anyone who's taken interest in this area. Alex's sister Charlotte is here today, I think, and has been a fearless campaigner for justice. Autistic individuals who, because of their condition, often do not have the cognitive ability to foresee a crime taking place are particularly vulnerable. Yet time and time again they've been convicted using this law. Partly because of these criticisms in 2016, the Supreme Court handed down a judgment in the case of Jogi In doing so, the court departed from precedent and stating that the law relating to joint enterprise had taken a wrong turn. This meant people could no longer be prosecuted for the possibility of foreseeing a crime taking place, but only if they intended to assist in committing it. That was a genuine moment of legal history, and the Supreme Court recognised that a colossal error had been made and many people had been prosecuted under an incorrect interpretation of the law. Now, you would have expected, Madam Deputy Speaker, that after such a significant change, there would have been a wave of successful appeals. However, this hasn't been the case. By last year, only 2 out of 103 appeals made with reference to Jogi have been successful. And this is partly because of the restrictive approach used by the courts in out-of-time approvals. Leave to appeal in these types of cases only be granted if the applicant can demonstrate that they have suffered substantial injustice because of the change of the law. The current interpretation of substantial injustice is uncertain at the best. There's been a changing range of factors identified by the court which applicants have had to meet to demonstrate they have suffered substantial injustice. At present, it seems to be that definition of substantial injustice in joint enterprise cases came from a notorious case in 2016. In this case, the court decided that appellants would have to prove that they would have been not guilty in their trial. For example, for murder cases, someone would have to satisfy the Court of Appeal that they would not have been convicted of murder. The test is higher than the mere safety required for an in-time appeal, and even higher still than the significant possibility that a jury would acquit the appellant. When the proportion of miscarriages of justice are so high in this area of law, it's reckoned that there are 1,000 mainly young men in prison as a result of this law. I failed to see the policy of justification for dealing in absolutes as the Court of Appeal have done. I understand the need for finality in criminal appeals, but it cannot become at the cost of the right to access a court for a fair trial. And at present, the process places a disproportionate burden on the appellant. In my view, 30 years of erroneously applying the common law should amount to a substantial injustice, and the people that have been convicted under this law deserve to have their appeals heard. The courts have failed to provide a mechanism for people that have been convicted under the pre-Jogi law to appeal their convictions, and we cannot continue to wait for the courts to assist these people. And it's time, and it's right, that for we as parliamentarians to act and right this injustice. And this brings me quickly to the substance of the bill. The Criminal Appeal Amendment Bill would amend the Criminal Appeal Act of 1968 by inserting a new subsection in Section 18. This would give leave to appeal against a criminal conviction for an offence which no longer exists, or if the offence has changed in a way which is material to the applicant's conviction. This includes the availability of a defence which did not previously exist. As I have said, a key principle in criminal appeals is finality. I accept there are legitimate policy reasons for restricting appeals. Can't have an appeal after appeal, and to maintain trust in the criminal justice system, cases must be settled and unfettered appeals must not be permitted. I agree with all that. Because of this, my bill includes a clause that would create conditions to using the new avenue of appeal. The application must be served before the conviction is spent, or there must be some other compelling reason why it is in the interests of justice to allow the appeal. This bill, if passed, would permit those convicted under the pre-Jogi joint enterprise law to appeal their convictions without having to pass the high bar set by the substantial injustice test. It will also remove the 28-day limit for change of law cases if they met conditions. In conclusion, this, Madam Deputy Speaker, as although you might not think so, is a simple bill which would have a great impact for a large amount of people. And due to the Ministry of Justice not holding figures on those convicted under joint enterprise, we don't know how many, but from estimates by Jengba and others, we know it's in the thousands. If passed, my bill will help provide those people with the access to justice we all deserve in a democratic society. Strengthening our justice system doesn't just benefit those who interact with it, it makes our entire society stronger. and ensures protection for every one of us whenever we may need it. Today, I hope all honourable and right honourable members will join with me in fixing up a major flaw in our justice system, making amends and taking a big step to guarantee the right to justice for every citizen. The law was wrong for 30 years, but it is now time for us to give the courts a chance to put it right. I commend my bill to the House.
The question is that the honourable member have leave to bring in the bill. As members of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Madam Deputy Speaker, Bob Neal, Kim Johnson, Andrew Mitchell, Yasmin Qureshi, Julie Elliott, Janet Davey, Dan Jarvis, Hilary Benn, Jim Shannon, Valerie Vaz, Kim Leadbeater and myself, Madam Deputy Speaker.
Mr. Barry Sherman.
Thank you. Criminal Appeal Amendment Bill.
Second reading, what day?
Friday, 20th of January, Madam Deputy Speaker.
Friday the 25th of January.
20th.
I misheard the honourable gentleman. Friday the 20th of January.
Thank you.